Okay, about these leading questions, according to this criminal procedure law and also this evidence law, in this examination of witnesses, we have this direct examination and also this cross-examination. Direct examination is if the prosecution is presenting a witness, and then the prosecution will first conduct this direct examination. And then after the prosecution's direct examination, the opposing party, that is the defense, may conduct cross-examination. According to law, leading questions are not permitted in direct examination. Leading questions are permitted in cross-examination. So what do we mean by leading questions? By a leading question is a question that can be answered by yes or no. So in direct examination, the attorney cannot ask leading questions. Meaning is, if you want this witness to testify about something, you have to ask the witness to say that by himself. You cannot really, for example, in this prosecution's case, the prosecutor cannot tell the story and ask the witness whether that is true or not. If you do that, and then the witness can always say yes or no, but that is not permitted. But this is really the point. In this Gideon's trial, Gideon presented a landlady of a hotel landlady to testify for him. Gideon had some marriage problem, so Gideon just stayed in a hotel instead of in his own home. Gideon wanted this landlady to testify that he was a nice person, he was very considerate. If it was late, if he wanted to make telephone calls and he would not really use the phone call in the hotel, he would always cross the street to use the public phone. So that is what he wanted the landlady to testify. And then we know in this case, because this witness was Gideon's witness, so Gideon was conducting the direct examination, so he could not ask leading questions. But Gideon just started to describe how he was making the phone call, he would cross the street. That is a leading question. And then right away, this prosecutor stood up saying, objection. The judge once again said, sustained. Meaning is, again, Gideon did something wrong in this courtroom. And then Gideon was very confused, and Gideon said, and then what can I do? The judge said, you have to ask the landlady to tell the story. You cannot really do it. So, this example of this Gideon's trial tells us, even in a simple case, it is difficult for one to conduct his own defense, especially if the person has no legal knowledge. As we can see from these two examples, if one is an examination of this witness' criminal record, another one is under what kind of circumstances you may ask leading questions, a lay person, it is not possible for a lay person to understand all these court proceedings. So Gideon tried his best to defend himself in this trial, but he was not successful. He was convicted and sentenced to 5 years imprisonment. When he was in prison, he sent this request to the U.S. Supreme Court. He said, according to the Sixth Amendment to the U.S. Constitution, he should have the right to counsel, but he was not provided with counsel, and he had to defend himself. So he argued that was a violation of his constitutional rights. The case went to the U.S. Supreme Court. The court actually sided with Gideon. the court indeed overturned Gideon's conviction because he was not represented by counsel. So the court said in this case, as the case demonstrated, the defendant, even in a simple case, could not effectively defend himself. So the defendant should be represented by counsel. I think just important for you to know, Gideon's case indeed was tried again. There was a second trial, and in his second trial, he was represented by a state-appointed lawyer. The lawyer very competently defended Gideon, and actually the lawyer exposed the prosecution's witness as the perpetrator of this crime. So as a result, Gideon was acquitted at this second trial. The significance of this case, once again, because this case was a felony case, so the interpretation of the case is, in all felony cases, if the defendant is indigent, there must be state-appointed free counsel. But of course, this is not the end of the inquiry. We know felony is a crime punishable by more than 1 year imprisonment. We also have this misdemeanor, that is a crime punishable by less than 1 year imprisonment. So if a person is on a trial for felony, the person is indigent, the person should enjoy this state-appointed counsel. But what if the person is on trial for a crime that is not a felony? So that is the issue we are going to discuss in this Augustiner versus Hamlin. In this case, the defendant was convicted of carrying a concealed weapon and was sentenced to 90 days in jail. So we know this is not felony, and because the imprisonment is not more than 1 year, so the sentence is not more than 1 year imprisonment. But it is very important for us to know the court in this right to counsel issue did not follow this distinction between felony and misdemeanor. We know misdemeanor is a crime punishable by less than 1 year imprisonment. The court did not really go by this distinction. The ruling of this court, the court in this case also overturned the conviction because the defendant was not represented by counsel. The court said, in all the cases, if the sentence is imprisonment, then the defendant, if indigent, must be represented by state-appointed counsel. It is very important for you to remember this case because the ruling of this case represents the current law. The current law regarding the right to counsel for indigent defendants is this. If the sentence is imprisonment, and then if the defendant is indigent, and then there must be state-appointed free counsel. This is the current law. So it is very important we know. If today, if we go to court and if we want to know under what kind of circumstances an indigent defendant may enjoy this state-appointed free counsel, that is, if the sentence is going to be imprisonment. Another way to understand this issue is simply this. If at the beginning of the trial, if the judge believes it is possible the defendant may be sentenced to imprisonment, and then he must appoint a lawyer for the defendant. If the court does not appoint a lawyer for the defendant, and then that simply means the court cannot sentence the defendant to imprisonment. So that's why we say the current law in this legal representation for indigent defendants is if the sentence is going to be imprisonment. If the actual sentence is imprisonment, and then there must be legal representation. So it is important for you to remember this is where the court. It is important for you to remember this because this is really where the court actually stopped. The court did not really go any further in this legal representation for indigent defendants. We can see this point in the next case. The last case we are going to discuss under this right to counsel. In this Scott versus Illinois, and we know in this case the defendant was convicted of shoplifting, but she was also indigent, and she requested to have a court-appointed counsel, and her request was denied, and she was convicted and sentenced to $50 in fine. And then she actually appealed the case to the U.S. Supreme Court, saying that I was indigent, I was not represented by counsel. That was why I was convicted and also sentenced to this $50 in fine. And then in this case, the court did not go further than this in whatever the court decided in this Singer versus Hamlin. The court said, the court in this case said, in your case, you are not going to have you do not have the right to have this state-appointed counsel because your sentence is not imprisonment. The court said, we are going to reaffirm under what kind of circumstances an indigent defendant should enjoy the state-appointed free counsel. That is only under the circumstances if the sentence is imprisonment. So this case demonstrates the court did not really go any further from this imprisonment ruling. That is, if the sentence is imprisonment, the defendant would have the right to have a state-appointed counsel. If the sentence is not imprisonment, and then the defendant does not have the right to state-appointed free counsel.